Yes.
In this case, I am filing the hard copy of a supplementary affidavit, which has been already filed, my lord, through the
A supplementary affidavit on behalf of the petitioner has been filed across the board. Let it be taken on record.
my lord, the application for anticipatory bail of NCR 307, 385, the minor sections of the Indian Penal Code, let be 27 Arms Act. My lord, as per the first
Only
information.
307. It
Yes.
has not come. It has not
No,
graduated
no.
to 302. Why supplementary affidavit? All that.
We have done
Let us
from-
see what is the allegation.
Allegation, my lord, is the informant says that he was constructing the house, which was objected, my lord, by the accused person, saying that you have encroached upon their land because by casting the roof. He called the police measured the same. They stated that no, he is well within his boundary. Then it is further alleged that at about 3, the petitioner and they again came. They tried to demolish the shuttering, which caused injury to one of the accused. And thereafter, my lord, it is alleged that this petitioner allegedly fired, causing injury on the hand of his brother,
आनंद कुमार यादव उर्फ नंदू यादव ने अपने कमर से पिस्तौल निकालकर मेरे भाई
संजीत कुमार को बाम में.
जो मोबाइल से वीडियो बना झुक गया तो गोली उसके दाहिने हाथ में लग गया.
Lord, this is the prosecution. Annexure 2, my lord, is the counter version from which
What is the injury?
my lord, that even the learned section judge has not mentioned. Matter has become settled between the party because all our neighbors.
Gunshot में settle तो नहीं होता, लेकिन let us see. We will call the informant and we will see. Matter has been settled.
Yes.
Why have you filed a supplementary?
Only for that purpose, my lord. And then, now, my lord,
Tell us about the nature. We'll say that you surrender and take bail. You're not in service or something.
no, he is publishing the books
That's
of,
all right.
of
So
several.
we will give you an observation that now the informant does not wish to prosecute the dispute with respect to the
Informant
land.
injured both, yes.
The dispute with respect to land in question where the construction was being carried out, that has been resolved. It is not an offence in public nature, it's a private offence. Of course, he has fired, but then the nature of injury is not life-threatening and it should be considered when you surrender. Heard Mr. Ajay Thakur, learned advocate for the petitioner and so and so. There has to be some kind of consistency in the orders. Now, had he been a young student or a lady or in service or working in armed forces, perhaps I could have made some departure. Now, no gunshot, suppose lathi injury would have been there. I would have granted you straight away because 307, even if it is non-compoundable, we are treating it as
That's what the full bench was often. Supreme Court has recently.
not in one case, but in several
Several, in
cases,
the
starting from Gyan.
Yes. Now, my
So
lord,
that's-
latest
that's-
is
there is no difficulty about it.
25th
But
of
not-
October.
But not with gunshot. Everywhere in Gyan Singh, Narinder Singh and later cases, gunshot injuries, they are not compoundable.
But
You can get anticipatory bail, but then
injury is, my lord, also not on record. From the session.
that's right.
Order
So
of the
we will-
learned
no,
session judge.
don't raise that issue.
Yes,
because
that's
if
why.
I say that,
No,
then
no.
the court below will look for the injury.
Exactly. And
So
then,
therefore-
my lord, we don't know what is the nature,
We,
what is the
we
injury.
understand. Therefore, in order to not to foment any further litigation between the neighbors,
Exactly.
I would have granted you bail, but for the fact that you have fired. That's the only question. So you surrender. We'll give you a good observation. Heard Mr. Ajay Thakur, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. Full stop. The accusation against the petitioner is of having fired from his weapon, which hit the brother of the informant in his hand. Full stop. There was a dispute between the parties with respect to a plot of land over which a construction was being carried out at the instance of the informant. Full stop. When that was protested, this occurrence is said to have taken place. Full stop. Learned counsel for the petitioner has submitted that though there is an accusation of firing from the weapon, but considering the futility of the litigation between the parties who are neighbors, the dispute between them has been resolved, and now the informant does not wish to prosecute the petitioner and other accused persons any further. Stop. he further submits, learned counsel for the petitioner further submits that according to his information, the injury suffered by the victim does not appear to be life-threatening. Notwithstanding the aforesaid arguments, I am not inclined to grant anticipatory bail to the petitioner for the reason that he is alleged to have opened fire which hit the victim. The prayer for anticipatory bail is rejected. However, if the petitioner surrenders before the court below and seeks bail, the court below shall consider that the informant now does not wish to prosecute the petitioner and other accused persons who are his neighbors, and the dispute over a plot of land on which the occurrence is said to have taken place has also been resolved, and that the petitioner is gainfully employed as a publisher of books, and shall pass orders, and that he does not have criminal antecedents, and shall pass and shall pass orders in accordance with law without being prejudiced by the fact that the present petition on his behalf has not been entertained.
Only one submission, informant and injured, because both have.
Informant and injured, injury जो है वो informant and injured. All right.
Cell 12, Mr. Ranjay Kumar Singh.
एक submission और था, case counter case, both sides have come.
ऊपर में लिखिएगा, learned counsel for the petitioner further submits that there is a counter version of the occurrence also in which anybody has been injured.
Yes, that is the present day
counter version of the occurrence in which some of the persons from the side of the petitioner also has been injured. First up, he further submits that there is no explanation in the subject of fire of the injuries suffered by the accused persons of the present case. First up, not with reject कर दी. All right.